Question 1. The assessment process reveals that a dominant firm in Alabama's agricultural equipment market has implemented a new pricing strategy that significantly undercuts its smaller competitors, leading to some of them exiting the market. While consumers are currently enjoying lower prices, there is concern that this conduct could lead to reduced long-term innovation and fewer choices if the dominant firm eventually gains a monopoly. Considering the principles of Alabama competition law, which analytical approach best guides the assessment of this firm's conduct? Option A. An approach that focuses exclusively on whether current consumer prices are lower, without considering potential future impacts on innovation, choice, or producer welfare. Option B. An approach that aims to preserve the existing competitive landscape by preventing any firm from gaining significant market share, even if its actions are efficient. Option C. An approach that prioritizes the protection of smaller competitors from aggressive pricing strategies, regardless of the impact on overall market efficiency or consumer prices. Option D. An approach that evaluates the overall economic efficiency and benefits to all market participants, including consumers and producers, to determine if the conduct maximizes societal welfare. Correct answer is D. An approach that evaluates the overall economic efficiency and benefits to all market participants, including consumers and producers, to determine if the conduct maximizes societal welfare. Explanation. The assessment process reveals a scenario where a dominant firm in the Alabama market for specialized industrial lubricants is accused of engaging in exclusionary conduct. The challenge lies in determining whether the firm's action, while potentially reducing competition among rivals, ultimately benefit consumers. This requires a careful balancing act, as different analytical frameworks can lead to vastly different conclusions about the legality of the conduct. Professionals must navigate the nuances of antitrust law in Alabama to ensure that enforcement promotes, rather than hinders, market efficiency and consumer well-being. The approach that represents best professional practice focuses on the total welfare standard. This standard considers the overall impact of a business practice on all stakeholders in the economy, including consumers and producers. In the context of Alabama antitrust law, which aims to foster robust competition and protect the economic interests of the state's residents, a total welfare analysis is most appropriate. It acknowledges that while some competitors might be harmed by a dominant firm's actions, if those actions lead to greater overall economic efficiency, lower production costs, or innovation that ultimately benefits a larger group of consumers through lower prices or improved products, then the conduct may be permissible. This aligns with the broader goals of antitrust policy to maximize societal economic welfare. An approach that solely focuses on consumer welfare, without considering producer welfare or overall economic efficiency, is professionally unacceptable in this context. While consumer welfare is a crucial component of antitrust analysis, an exclusive focus can lead to outcomes that are detrimental to overall economic efficiency. For instance, it might prohibit conduct that, while temporarily increasing prices for some consumers, spurs innovation or cost reductions that lead to significantly lower prices or better products for a much larger group of consumers in the long run. This narrow perspective fails to capture the full economic impact and can result in inefficient outcomes that do not serve the broader public interest as envisioned by Alabama's competition laws. Another professionally unacceptable approach is one that prioritizes the protection of individual competitors over the broader market and consumer interests. Antitrust law is not designed to shield inefficient businesses from competition, focusing on whether specific rivals are harmed, without a comprehensive analysis of the impact on the market as a whole and on consumers, is a misapplication of antitrust principles. This approach can lead to the preservation of less efficient firms, stifle innovation, and ultimately result in higher prices or lower quality goods for consumers, contrary to the objectives of Alabama's competition laws. The professional decision-making process for similar situations should involve a thorough economic analysis that considers both the direct and indirect effects of the challenged conduct on all market participants. This includes evaluating potential pro-competitive justifications for the conduct, assessing the likelihood and magnitude of harm to consumers, and weighing these against any potential benefits to overall economic efficiency. Professionals must be adept at applying established economic principles and legal precedents within the specific framework of Alabama's antitrust statutes to arrive at a well-reasoned and defensible conclusion. Question 2. Process analysis reveals that a dominant firm in the Alabama market for specialized industrial lubricants has recently implemented a pricing strategy that significantly undercuts its smaller competitors, leading to some of them reducing their operations. Considering Alabama competition law, which of the following analytical approaches best addresses whether this conduct is likely to be deemed anti-competitive? Option A. Analyze the firm's pricing solely in relation to its own historical costs, without considering the broader market structure, the actions of competitors, or the potential for new market entry. Option B. Immediately conclude that any aggressive pricing strategy, especially one that causes competitors to scale back, is a per se violation of Alabama competition law, regardless of market conditions or the firm's intent. Option C. Conduct a comprehensive analysis of the relevant product and geographic markets to determine the firm's market power and assess the potential for substantial lessening of competition or monopolization, considering factors like market concentration, barriers to entry, and product substitutability. Option D. Focus on the absolute size and revenue of the dominant firm, assuming that any firm with substantial financial resources has the capacity to engage in anti-competitive practices. The correct answer is C. Conduct a comprehensive analysis of the relevant product and geographic markets to determine the firm's market power and assess the potential for substantial lessening of competition or monopolization, considering factors like market concentration, barriers to entry, and product substitutability. Explanation. Scenario analysis. This scenario is professionally challenging because it requires a nuanced understanding of market structure and its implications for competition under Alabama law. Determining whether a firm's actions constitute anti-competitive behavior necessitates evaluating the relevant market, the firm's market power within that market, and the potential impact on competition. Misjudging these factors can lead to incorrect assessments of legality, potentially resulting in regulatory scrutiny or missed opportunities to address genuine competitive harms. Careful judgment is required to distinguish between aggressive but lawful competition and conduct that violates Alabama's antitrust provisions. Correct approach analysis. The best professional approach involves a thorough analysis of the relevant product and geographic markets to understand the competitive landscape. This includes assessing the degree of market concentration, the ease of entry for new competitors, and the substitutability of products or services. Once the market is defined, the firm's market share and its ability to control prices or exclude competitors within that market must be evaluated. This comprehensive market structure analysis, grounded in the principles of Alabama competition law, allows for an informed determination of whether the firm's conduct is likely to substantially lessen competition or tend to create a monopoly, which are key considerations under state antitrust statutes. Incorrect approaches analysis. One incorrect approach is to focus solely on the firm's absolute size or revenue without considering its market share within a defined relevant market. Alabama competition law is concerned with market power and its exercise, not simply bigness. Another incorrect approach is to assume that any aggressive pricing strategy, such as a temporary price reduction, is inherently anti-competitive without examining its purpose and effect on the overall market structure and competitors. Such an approach ignores the possibility of legitimate competitive responses. Finally, an approach that disregards the potential for new market entry or the availability of close substitutes, and instead relies on a static view of the market, fails to capture the dynamic nature of competition that Alabama law seeks to protect. Professional reasoning. Professionals should adopt a structured decision-making process that begins with defining the relevant market. This is followed by an assessment of market power within that market, considering factors like market share, barriers to entry, and product substitutability. The analysis then moves to evaluating the specific conduct in question and its likely impact on competition, referencing relevant Alabama statutes and case law. This systematic approach ensures that conclusions are based on a robust understanding of market dynamics and legal requirements, rather than assumptions or incomplete information. Question 3. The efficiency study reveals that a dominant grocery retailer in Alabama has implemented a new loyalty program that offers significantly deeper discounts to customers who exclusively shop at their stores, coupled with a policy of demanding exclusive supply agreements from key local producers. Considering the principles of Alabama competition law, which of the following best describes the appropriate analytical framework for assessing whether these practices constitute an abuse of dominance? Option A. An assumption that any aggressive pricing strategy or preferential treatment of customers by a dominant firm is an abuse, without further investigation into the specific conduct and its market effects. Option B. A determination based solely on the dominant retailer's substantial market share in Alabama, and the fact that smaller competitors are experiencing reduced sales as a result of the loyalty program. Option C. An immediate conclusion that the exclusive supply agreements are illegal per se, regardless of their impact on competition or any potential benefits to consumers or producers. Option D. A comprehensive assessment of the loyalty program and exclusive supply agreements to determine if they are likely to harm competition in the relevant grocery market by excluding rivals or distorting market access for producers, while also considering any potential pro-competitive justifications. The correct answer is D. A comprehensive assessment of the loyalty program and exclusive supply agreements to determine if they are likely to harm competition in the relevant grocery market by excluding rivals or distorting market access for producers, while also considering any potential pro-competitive justifications. Explanation. The efficiency study reveals a potential for abuse of dominance by a large retail chain in Alabama's grocery market. This scenario is professionally challenging because determining whether a firm's conduct constitutes an abuse of dominance under Alabama competition law requires a nuanced understanding of market dynamics, the firm's intent, and the impact on competition, rather than a simple quantitative threshold. The law aims to protect the competitive process, not necessarily individual competitors, and distinguishing between aggressive but lawful competition and anti-competitive abuse is critical. The best approach involves a comprehensive assessment of the retail chain's practices against the principles of Alabama competition law, specifically focusing on whether its actions are likely to harm competition in the relevant market. This includes examining whether the chain is leveraging its market power to exclude rivals, engage in predatory pricing, or impose unfair terms on suppliers or consumers. The analysis must consider the specific conduct in question, its economic effects, and whether it is objectively justifiable by pro-competitive efficiencies. Alabama law, like general competition principles, prohibits abuses that restrict or distort competition, and a thorough investigation into the nature and effect of the alleged abusive conduct is paramount. An incorrect approach would be to solely focus on the retail chain's market share or profitability as definitive proof of abuse. While these factors can be indicators, they do not, in themselves, constitute an abuse under Alabama law. The law requires evidence of conduct that actively harms the competitive process. Another incorrect approach would be to assume that any action taken by a dominant firm that disadvantages smaller competitors is automatically an abuse. Competition law permits firms to compete vigorously, and the focus must be on whether the conduct is anti-competitive in its effect on the market structure and the ability of other firms to compete, not merely on the impact on a specific rival. Finally, relying on anecdotal evidence or customer complaints without a systematic analysis of market impact and legal standards would also be an inadequate and potentially flawed approach. Professionals should approach such situations by first defining the relevant market, then assessing the market power of the firm in question. Subsequently, they must meticulously examine the specific conduct alleged to be abusive, evaluating its nature, intent, and most importantly, its actual or likely effect on competition within that market. This requires gathering evidence, applying legal tests, and considering any potential pro-competitive justifications offered by the firm, all within the framework of Alabama competition law. Question 4. The assessment process reveals a scenario involving a local bakery in Birmingham, Alabama, that sells artisanal bread. Several other bakeries in the immediate vicinity also sell similar artisanal bread, and new bakeries can open with relatively low startup costs. The bakery in question has a moderate market share and faces significant competition from these other local establishments. Considering the principles of Alabama's competition law, which of the following best describes the market structure in which this bakery operates? Option A. A market with a few dominant sellers who are interdependent in their pricing and output decisions, characteristic of an oligopoly. Option B. A market where firms are highly profitable due to extensive brand loyalty and minimal direct competition, regardless of other structural factors. Option C. A market dominated by a single seller with substantial control over pricing and significant barriers to entry indicative of a monopoly. Option D. A market characterized by a large number of sellers offering differentiated products, low barriers to entry, and limited control over pricing, most closely resembling perfect competition. The correct answer is D. A market characterized by a large number of sellers offering differentiated products, low barriers to entry, and limited control over pricing, most closely resembling perfect competition. Explanation. The assessment process reveals a scenario that is professionally challenging due to the need to accurately categorize market structures under Alabama's competition law framework. Mischaracterizing a market can lead to incorrect antitrust analysis, potentially resulting in the pursuit of enforcement actions against legitimate business practices, or, conversely, failing to address anti-competitive conduct. Careful judgment is required to apply the theoretical concepts of market structures to real-world business operations within the specific legal context of Alabama. The best professional approach involves a comprehensive analysis of market characteristics, focusing on the number of firms, product differentiation, barriers to entry, and the degree of price control, all viewed through the lens of Alabama's antitrust statutes. This approach is correct because it directly addresses the core elements that define market structures as understood by competition law. By meticulously examining these factors, professionals can accurately determine whether a market most closely resembles perfect competition, monopoly, or oligopoly, thereby informing appropriate legal and business strategies. This aligns with the objective of Alabama's competition law to foster a competitive marketplace. An incorrect approach would be to solely focus on the profitability of firms within a market. While profitability is an outcome of market dynamics, it is not a defining characteristic of a market structure itself. A highly profitable market could still be perfectly competitive if the conditions for such a structure are met, or it could be a monopoly. Relying on profitability alone would lead to misclassification and potentially flawed legal conclusions, failing to uphold the principles of Alabama's competition law. Another incorrect approach would be to classify a market based on the perceived size of the largest firm, without considering the number of other competitors or the ease of market entry. Alabama's competition law recognizes that market power can be dispersed or concentrated, and a single large firm does not automatically equate to a monopoly or oligopoly if other competitive forces are present. This approach ignores crucial elements of market structure analysis and could lead to an inaccurate assessment of competitive conditions. Finally, an incorrect approach would be to categorize a market based on the subjective perception of consumers regarding product similarity, without objectively assessing product differentiation and the availability of close substitutes. Alabama's competition law requires an objective analysis of market characteristics. Consumer perception, while important in some contexts, is not a sufficient standalone criterion for defining market structure without supporting evidence of product attributes and competitive alternatives. Professionals should employ a structured decision-making process that begins with understanding the specific market being analyzed. This involves gathering data on the number and size of firms, the nature of the products or services offered, the existence and magnitude of barriers to entry, and the pricing behavior of firms. This information should then be systematically compared against the established criteria for perfect competition, monopoly, and oligopoly, always referencing the principles and objectives of Alabama's competition law. This rigorous, evidence-based approach ensures accurate classification and supports sound legal and business decision-making. Question 5. The assessment process reveals that Dixie Dynamics, Inc., a manufacturing firm based in Birmingham, Alabama, has entered into an agreement with a key supplier located in Georgia. This agreement, while primarily concerning the supply chain for Dixie Dynamics' U.S. operations, includes clauses that dictate the pricing of components that are subsequently incorporated into finished goods exported and sold within the European Union. If these clauses are found to restrict competition within the EU's internal market, what is the most appropriate approach for Dixie Dynamics to consider regarding the potential applicability of European Union competition law, specifically Articles 101 and 102 TFEU? Option A. Conduct a detailed analysis of the agreement's specific terms and the downstream impact on competition within the EU internal market to determine if the conduct falls within the extraterritorial scope of Articles 101 and 102 TFU. Option B. Rely on the fact that the agreement was negotiated and executed within the United States to assert that EU competition law cannot have jurisdiction over the matter. Option C. Assume that any agreement impacting goods sold in the EU, regardless of the directness or significance of the impact, automatically triggers Article 101 TFU and therefore cease all exports to the EU. Option D. Conclude that since Dixie Dynamics is an Alabama-based company and its primary agreement is with a U.S. supplier, EU competition law is not applicable, and focus solely on compliance with U.S. antitrust regulations. Correct answer is A. Conduct a detailed analysis of the agreement's specific terms and the downstream impact on competition within the EU internal market to determine if the conduct falls within the extraterritorial scope of Articles 101 and 102 TFU. Explanation. The assessment process reveals a scenario that is professionally challenging due to the nuanced application of European Union competition law, specifically Articles 101 and 102 TFU, within the context of a hypothetical Alabama business. The core challenge lies in determining the extraterritorial reach of EU competition law and the potential implications for a company whose primary operations are based in Alabama, but whose conduct might affect competition within the European Union. Careful judgment is required to avoid both overreach and underestimation of regulatory scrutiny. The best professional approach involves a thorough analysis of the company's specific activities and their direct, significant, and foreseeable impact on competition within the EU internal market. This approach correctly recognizes that, while the company is based in Alabama, EU competition law can apply if its conduct has effects within the EU. This aligns with the established principles of the effects doctrine in EU competition law, which asserts jurisdiction over conduct occurring outside the EU if it has a direct, immediate, and foreseeable impact on competition within the EU. This doctrine is a cornerstone of the TFU extraterritorial application and is designed to protect the integrity of the EU's internal market from anti-competitive practices, regardless of their origin. An incorrect approach would be to assume that because the company is headquartered and operates primarily in Alabama, it is automatically exempt from EU competition law. This fails to acknowledge the extraterritorial reach of EU competition law and the effects doctrine. Such an assumption could lead to significant legal and financial penalties if the company's actions are found to violate Articles 101 or 102 TFU. Another incorrect approach would be to solely focus on U.S. antitrust laws, neglecting the potential for EU jurisdiction. While U.S. laws are relevant to the company's domestic operations, they do not preclude the application of EU law if the necessary jurisdictional nexus is established. A third incorrect approach would be to engage in broad, speculative interpretations of potential EU law violations without concrete evidence of direct and significant effects on the EU market. This lacks the precision and evidentiary basis required for a sound legal assessment. The professional reasoning process for similar situations should involve a multi-step analysis. First, identify the relevant jurisdictions whose laws might apply based on the company's operations and the markets it serves. Second, for each potentially applicable jurisdiction, determine the specific legal provisions that might be triggered. Third, critically assess the jurisdictional basis for each law, paying close attention to principles like the effects doctrine for extraterritorial application. Fourth, gather specific facts and evidence to support or refute the applicability of each law. Finally, consult with legal counsel specializing in the relevant jurisdictions to ensure compliance and mitigate risk. Question 6. Risk assessment procedures indicate that a multinational corporation, headquartered in Germany, is engaging in practices that appear to restrict competition in the global market for specialized industrial components. While these practices are occurring outside of Alabama, there is evidence suggesting a significant and foreseeable negative impact on Alabama-based manufacturers and consumers of these components. In assessing potential legal exposure under Alabama antitrust law, which of the following approaches represents the most prudent and legally sound strategy? Option A. Apply general principles of international antitrust law without a specific examination of the Alabama Antitrust Act of 1974, as global conduct is typically governed by international norms. Option B. Focus solely on compliance with German and any other relevant foreign antitrust regulations, assuming they adequately address the competitive concerns. Option C. Conduct a detailed analysis of the Alabama Antitrust Act of 1974 to determine if the extraterritorial conduct has a direct, substantial, and foreseeable anti-competitive effect on commerce within Alabama, and consult with legal counsel specializing in Alabama antitrust law. Option D. Conclude that since the conduct originates and primarily occurs outside of Alabama, it falls outside the jurisdiction of Alabama's antitrust laws. The correct answer is C. Conduct a detailed analysis of the Alabama Antitrust Act of 1974 to determine if the extraterritorial conduct has a direct, substantial, and foreseeable anti-competitive effect on commerce within Alabama, and consult with legal counsel specializing in Alabama antitrust law. Explanation. Scenario analysis. This scenario presents a professional challenge because it requires an understanding of how Alabama's antitrust laws interact with the broader principles of global competition law, particularly when a company operates internationally. The challenge lies in discerning which legal framework takes precedence or how they are reconciled when potential anti-competitive conduct has effects in multiple jurisdictions, including Alabama. Careful judgment is required to ensure compliance with both state and potentially federal or international antitrust obligations, without creating undue burdens or conflicting legal positions. Correct approach analysis. The best professional practice involves a thorough analysis of the extraterritorial reach of Alabama's antitrust laws, specifically the Alabama Antitrust Act of 1974, and how it applies to conduct occurring outside the state that has a direct, substantial, and foreseeable anti-competitive effect within Alabama. This approach correctly recognizes that state antitrust laws can have extraterritorial application if the conduct impacts the relevant market within the state. It necessitates consulting legal counsel specializing in Alabama antitrust law to determine the specific scope of the act and its enforcement against foreign conduct. This aligns with the principle of protecting Alabama's commerce from anti-competitive practices, regardless of where the conduct originates, as long as the impact is felt within the state. Incorrect approaches analysis. One incorrect approach is to assume that conduct occurring entirely outside of Alabama is beyond the purview of Alabama antitrust law, even if it demonstrably harms competition within Alabama. This fails to acknowledge the potential extraterritorial application of state antitrust statutes when there is a sufficient nexus to the state's commerce. Another incorrect approach is to solely rely on the antitrust laws of the foreign jurisdiction where the conduct occurs, without considering whether that conduct also violates Alabama's laws. While foreign law is relevant, it does not automatically preempt the application of Alabama's own antitrust statutes if the necessary jurisdictional elements are met. A further incorrect approach is to ignore the potential for overlapping jurisdiction and simply apply general principles of international antitrust law without a specific analysis of Alabama's statutory framework. While international principles inform antitrust analysis, Alabama's specific statutory language and judicial interpretations are paramount for determining compliance within the state. Professional reasoning. Professionals facing such a situation should first identify the specific Alabama antitrust statutes that might be implicated. They should then assess the nature and extent of the alleged anti-competitive conduct and its direct, substantial, and foreseeable impact on competition within Alabama. Consulting with legal counsel experienced in Alabama antitrust law is crucial to navigate the complexities of extraterritorial application and potential conflicts of law. A risk-based approach, prioritizing compliance with the most stringent applicable laws, is essential. Question 7. What factors determine whether a proposed merger between two companies operating within Alabama's retail grocery sector would violate the Sherman Act, Clayton Act, or Federal Trade Commission Act? Option A. An assessment solely of whether the merging companies are currently engaged in direct price fixing or explicit market allocation agreements within Alabama. Option B. A comprehensive analysis of the relevant product and geographic markets in Alabama, the degree of market concentration, the potential for the merged entity to unilaterally or collusively raise prices or reduce output, barriers to entry for new competitors, and the overall impact on consumer choice and welfare. Option C. A review of the projected cost savings and operational efficiencies expected to result from the merger, without significant consideration of market dynamics in Alabama. Option D. A determination based on whether the merging companies operate in slightly different, but related, subsectors of the Alabama retail grocery market, thereby avoiding direct overlap. The correct answer is B. A comprehensive analysis of the relevant product and geographic markets in Alabama, the degree of market concentration, the potential for the merged entity to unilaterally or collusively raise prices or reduce output, barriers to entry for new competitors, and the overall impact on consumer choice and welfare. Explanation. This scenario presents a professional challenge because it requires a nuanced understanding of how the Sherman Act, Clayton Act, and FTC Act interact to prevent anti-competitive practices, specifically in the context of a merger. The challenge lies in accurately assessing whether the proposed merger's potential effects on competition in Alabama's market violate federal antitrust laws, necessitating a careful evaluation of market power, barriers to entry, and potential consumer harm. The best professional approach involves a comprehensive analysis of the proposed merger's likely impact on competition within Alabama, considering factors such as market concentration, the potential for the merged entity to raise prices or reduce output, and the likelihood of stifling innovation. This approach aligns with the spirit and intent of the Sherman Act, prohibiting unreasonable restraints of trade. The Clayton Act, specifically addressing mergers that may substantially lessen competition or tend to create a monopoly, and the FTC Act, prohibiting unfair methods of competition. Regulatory bodies like the Federal Trade Commission, FTC, and the Department of Justice, DOJ, would scrutinize such a merger by examining market definition, market shares, the nature of the products or services, and the potential for coordinated or unilateral anti-competitive conduct post-merger. This thorough, evidence-based assessment is crucial for determining if the merger poses a significant threat to Alabama consumers and the competitive landscape. An incorrect approach would be to solely focus on the immediate financial benefits or operational efficiencies of the merger, without adequately considering its potential anti-competitive consequences. This fails to address the core concerns of antitrust law, which prioritize market competition and consumer welfare over private gains that could harm the public. Another incorrect approach would be to assume that, because the companies operate in different segments of the Alabama market, their merger cannot be anti-competitive. This overlooks the possibility of indirect competition or the creation of a dominant firm that could leverage its position to harm rivals or consumers. Finally, relying only on the absence of explicit price fixing or market allocation agreements would be insufficient. Antitrust law, particularly the Clayton Act, is designed to prevent mergers that have the potential to substantially lessen competition, even if no overt illegal agreements are present. Professionals should employ a decision-making framework that begins with clearly defining the relevant product and geographic markets within Alabama. This is followed by an assessment of market concentration, e.g., using the Herfindahl-Hirschman Index, and an evaluation of the merger's potential to increase market power. Crucially, this analysis must consider the likelihood of new entry into the market and the potential for the merged firm to engage in exclusionary conduct or raise prices. The ultimate decision should be guided by whether the merger is likely to result in a substantial lessening of competition or tend to create a monopoly, thereby harming consumers in Alabama. Question 8. Strategic planning requires a thorough evaluation of potential business ventures. In Alabama, a company is considering a joint venture with another firm that operates in a complementary but not directly competing market. The primary motivation for the joint venture is to achieve significant cost synergies and expand market reach. What is the most prudent approach to ensure compliance with Alabama's competition law? Option A. Conduct a comprehensive analysis of the joint venture's potential impact on competition within Alabama, including market definition, market power, and the likelihood of adverse effects on consumers and competitors, and advise against proceeding if significant risks are identified. Option B. Rely exclusively on the advice of legal counsel regarding the antitrust implications, without independently assessing the core competition law principles involved in the proposed venture. Option C. Proceed with the joint venture, focusing solely on the projected cost savings and market expansion benefits, assuming that complementary markets do not pose an antitrust risk under Alabama law. Option D. Assume that because the firms are not direct competitors, their agreement is inherently lawful under Alabama's competition law and does not require further antitrust scrutiny. The correct answer is A. Conduct a comprehensive analysis of the joint venture's potential impact on competition within Alabama, including market definition, market power, and the likelihood of adverse effects on consumers and competitors, and advise against proceeding if significant risks are identified. Explanation: this scenario is professionally challenging because it requires a nuanced understanding of Alabama's competition law to balance legitimate business interests with the prohibition of anti-competitive practices. The core challenge lies in distinguishing between aggressive but lawful competition and agreements that unlawfully restrain trade. Careful judgment is required to avoid inadvertently engaging in or facilitating conduct that violates Alabama law. The best professional approach involves conducting a thorough, objective analysis of the proposed joint venture's potential impact on competition within Alabama. This includes assessing market definition, market power of the parties, potential for collusion, and the likelihood of significant adverse effects on consumers or other businesses. If the analysis reveals a substantial risk of violating Alabama's competition law, the responsible professional must advise against proceeding with the venture in its current form and explore alternative, lawful structures or strategies. This approach is correct because it prioritizes compliance with Alabama's antitrust statutes, such as the Alabama Antitrust Act of 1974, which aims to prevent monopolies and restraints of trade. By proactively identifying and mitigating potential legal risks, this approach upholds ethical obligations and protects the company from severe penalties, including fines and injunctions. An approach that focuses solely on the potential for increased profits without a corresponding assessment of competitive impact is professionally unacceptable. This failure to consider the legal ramifications of the joint venture could lead to violations of Alabama's competition law by creating a situation where the combined entities could unduly influence prices, restrict output, or exclude competitors, thereby harming consumers and the competitive landscape. Another professionally unacceptable approach is to assume that because the parties are not direct competitors, their agreement cannot be anti-competitive. This overlooks the possibility of indirect anti-competitive effects, such as facilitating collusion in adjacent markets or creating a dominant firm that can leverage its power to the detriment of competition. Alabama's competition law is broad enough to capture various forms of restraints of trade, not just those between direct rivals. Finally, relying on the advice of legal counsel without independently understanding the core competition law principles involved is insufficient. While legal counsel is crucial, professionals have an ethical duty to understand the fundamental legal boundaries of their actions. Blindly following advice without grasping the underlying competition law rationale can lead to misinterpretations and unintentional violations, especially if the legal advice is not fully informed about the specific business context, or if the professional fails to provide complete information. The professional decision-making process for similar situations should involve a structured risk assessment framework. This begins with clearly defining the business objective, then identifying potential competition law implications under Alabama statutes. This should be followed by a thorough analysis of market dynamics and the proposed conduct's likely effects. If significant risks are identified, the next step is to consult with experienced antitrust counsel specializing in Alabama law, providing them with all relevant information. Based on that advice, the professional must then decide whether to proceed, modify the plan, or abandon it, always prioritizing compliance and the long-term health of the market. Question 9. System analysis indicates that a company operating within Alabama is considering a new pricing strategy that could potentially impact competition within the state. To ensure compliance, what is the most prudent approach for assessing the legality of this strategy under Alabama's antitrust framework, considering the potential interplay with federal antitrust laws? Option A. Focus exclusively on the Alabama Antitrust Act, disregarding any federal antitrust laws that might also apply to the company's operations. Option B. Conduct a comprehensive review of the Alabama Antitrust Act and relevant federal antitrust laws, analyzing their specific provisions, case law, and potential interaction to ensure compliance with the most stringent applicable standards. Option C. Solely rely on interpretations and enforcement actions related to federal antitrust laws, assuming they fully encompass Alabama's regulatory requirements. Option D. Apply general principles of antitrust law without specific reference to the Alabama Antitrust Act, assuming state laws are merely duplicative of federal statutes. The correct answer is B. Conduct a comprehensive review of the Alabama Antitrust Act and relevant federal antitrust laws, analyzing their specific provisions, case law, and potential interactions to ensure compliance with the most stringent applicable standards. Explanation. Scenario analysis. This scenario presents a professional challenge because it requires a nuanced understanding of how Alabama's antitrust laws interact with federal antitrust principles, particularly when a business operates across state lines. The challenge lies in identifying which legal framework takes precedence or how they are harmonized to ensure compliance and avoid potential violations. Misinterpreting this interplay could lead to significant legal and financial repercussions for the company. Correct approach analysis. The best professional practice involves a thorough analysis of both the Alabama Antitrust Act and relevant federal antitrust laws, such as the Sherman Act and the Clayton Act, to determine their applicability and potential conflicts. This approach recognizes that, while Alabama has its own statutory framework, federal law often sets a baseline and can preempt state law in certain circumstances, or state law can provide additional protections. The correct approach prioritizes understanding the specific provisions of the Alabama Antitrust Act, including its definitions, prohibitions, and enforcement mechanisms, and then assessing how these align with or differ from federal standards. It also necessitates considering any case law that interprets the interaction between Alabama and federal antitrust provisions. This comprehensive review ensures that the company's actions are compliant with the most stringent applicable standards and that potential areas of conflict are identified and addressed proactively. Incorrect approaches analysis. One incorrect approach would be to solely rely on federal antitrust laws and disregard the Alabama Antitrust Act. This fails to acknowledge that state laws can offer broader protections or have specific provisions that are not mirrored at the federal level. Alabama's act may have unique definitions or enforcement powers that, if ignored, could lead to violations of state law even if federal law is satisfied. Another incorrect approach would be to assume that the Alabama Antitrust Act is identical to federal law and apply federal interpretations without careful examination of the state statute's specific language and legislative intent. This overlooks potential differences in scope, intent, or enforcement that could render a business practice legal under federal law, but illegal under Alabama law. Finally, an approach that focuses only on the most restrictive interpretation of either federal or state law without a comparative analysis would be inefficient and potentially overly cautious, leading to unnecessary business limitations. Professional reasoning. Professionals should approach this situation by first identifying all potentially applicable antitrust laws, both at the state, Alabama, and federal levels. They should then conduct a detailed comparative analysis of these laws, paying close attention to definitions, prohibited conduct, burdens of proof, and remedies. This involves consulting the Alabama Antitrust Act, relevant federal statutes, and authoritative case law interpreting both. The goal is to identify any areas where state and federal laws diverge or where state law provides additional protections or prohibitions. This systematic comparison allows for the development of a compliance strategy that satisfies the requirements of all applicable jurisdictions, thereby mitigating risk and ensuring lawful business operations. Question 10. The monitoring system demonstrates that Southern Steelworks, Inc., a hypothetical Alabama-based steel manufacturer, proposes to acquire Birmingham Bolt Co., another hypothetical Alabama-based steel manufacturer. Southern Steelworks, Inc., had annual sales of steel products in Alabama totaling $50 million in the most recent fiscal year, and Birmingham Bolt Co. had annual sales of steel products in Alabama totaling $30 million in the most recent fiscal year. The relevant geographic market is the state of Alabama, and the combined entity would hold an estimated 40% market share of steel product sales within Alabama. There are no specific dollar thresholds for mandatory pre-merger notification under Alabama law, assuming no significant efficiencies are generated by this merger. What is the most appropriate initial assessment of the competitive implications under Alabama antitrust law? Option A. The merger should be allowed to proceed as long as the merging companies believe it will create efficiencies, as efficiency gains are the primary consideration for mergers in Alabama. Option B. Since there are no mandatory pre-merger notification dollar thresholds in Alabama, the merger can proceed without further antitrust scrutiny. Option C. The combined entity's significant market share, 40%, in Alabama warrants further investigation under the Alabama Antitrust Act of 1974 to determine if the merger substantially lessens competition or tends to create a monopoly within the state. Option D. The merger is unlikely to violate Alabama antitrust law because both companies are based in Alabama, and the focus of Alabama antitrust law is typically on out-of-state entities engaging in anti-competitive practices within the state. The correct answer is C. The combined entity's significant market share, 40%, in Alabama warrants further investigation under the Alabama Antitrust Act of 1974 to determine if the merger substantially lessens competition or tends to create a monopoly within the state. Explanation: the monitoring system demonstrates a scenario that is professionally challenging due to the need to accurately assess the potential anti-competitive effects of a merger under Alabama's specific merger control regime, which requires careful application of economic principles and adherence to statutory thresholds. The challenge lies in correctly interpreting the relevant market shares and determining whether the proposed transaction meets the notification thresholds or raises significant competitive concerns, necessitating a deep understanding of Alabama antitrust law, particularly the Alabama Antitrust Act of 1974. The best professional approach involves a precise calculation of the combined market share of the merging entities within the relevant product and geographic market, and comparing this to any statutory thresholds for mandatory pre-merger notification or presumptive illegality under Alabama law. This approach is correct because it directly addresses the core of merger control analysis, determining if a transaction is likely to substantially lessen competition or tend to create a monopoly within Alabama. Alabama's antitrust laws, while not having a dedicated federal-style pre-merger notification system with specific dollar thresholds like the Hart-Scott-Rodino Act, still empower the Attorney General to investigate and challenge mergers that violate Section 6-5-60 of the Code of Alabama, which prohibits contracts, combinations, or conspiracies in restraint of trade. Therefore, a quantitative assessment of market share is a fundamental step in identifying potentially problematic mergers. An incorrect approach would be to solely rely on the absence of a specific dollar threshold for mandatory pre-merger notification in Alabama to conclude that no review is necessary. This fails to recognize that Alabama law grants the Attorney General broad investigatory powers to challenge mergers that harm competition, regardless of whether they trigger federal notification requirements. Another incorrect approach would be to focus only on the potential efficiencies of the merger, without first establishing that the merger does not violate Alabama's antitrust provisions. While efficiencies can be a defense, they are secondary to the primary inquiry of whether the merger itself is anti-competitive. A further incorrect approach would be to assume that because the merging parties are located outside of Alabama, the transaction falls outside the purview of Alabama antitrust law. Alabama's antitrust laws apply to any contract, combination, or conspiracy that has a direct, substantial, and reasonably foreseeable anti-competitive effect within the state. A professional decision-making process for similar situations should begin with a thorough understanding of the relevant state antitrust laws, including any specific provisions related to mergers. This should be followed by a quantitative analysis of market shares within the relevant Alabama market. If the analysis suggests potential anti-competitive effects or triggers any state-specific review triggers, a qualitative assessment of the merger's impact on competition, including potential efficiencies, should be conducted. Finally, legal counsel specializing in Alabama antitrust law should be consulted to ensure full compliance and to navigate any potential challenges. Question 11. Risk assessment procedures indicate that a large beverage distributor in Alabama is considering acquiring a smaller, independent bottler within the same state. The distributor argues that this acquisition will lead to significant cost savings through economies of scale, allowing them to offer more competitive pricing to Alabama retailers. However, the acquisition would reduce the number of independent bottlers in Alabama by 20%, potentially giving the acquiring distributor a dominant market share in certain regions of the state. Considering the definition and objectives of Alabama's competition law, which of the following approaches best guides the distributor's decision-making process? Option A. Proceed with the acquisition, assuming that any efficiency gains and potential for lower consumer prices automatically satisfy the objectives of Alabama's competition law, regardless of the impact on market concentration. Option B. Conduct a thorough analysis to determine if the proposed acquisition would substantially lessen competition or tend to create a monopoly in any relevant market within Alabama, with a primary focus on the impact on consumer welfare and the preservation of a competitive marketplace. Option C. Focus exclusively on the potential cost savings and operational efficiencies for the acquiring distributor, without independently assessing the broader implications for competition and consumer choice within Alabama. Option D. Rely on the fact that no direct competitor has raised concerns about the acquisition, interpreting this as an indication that the transaction will not violate Alabama's competition law. Correct answer is B. Conduct a thorough analysis to determine if the proposed acquisition would substantially lessen competition or tend to create a monopoly in any relevant market within Alabama, with a primary focus on the impact on consumer welfare and the preservation of a competitive marketplace. Explanation. The scenario presents a common challenge in business operations, where a company might engage in practices that could potentially stifle competition within Alabama. The professional challenge lies in discerning whether a specific business practice, even if seemingly beneficial for the company's immediate growth, aligns with the broader objectives of Alabama's competition law. This requires a nuanced understanding of how market dynamics, consumer welfare, and fair competitive practices are protected under state law. Careful judgment is required to avoid actions that, while appearing efficient, could lead to anti-competitive outcomes. The best professional practice involves a proactive and comprehensive assessment of business strategies against the foundational principles of Alabama's competition law. This approach prioritizes understanding the law's core objectives: to promote robust competition, prevent monopolies and unreasonable restraints of trade, and ensure that consumers benefit from lower prices, higher quality, and greater innovation. By focusing on whether a proposed action would likely harm competition or consumers in Alabama, a company can make informed decisions that are compliant and ethically sound. This aligns with the spirit and letter of Alabama's antitrust statutes, which aim to preserve a dynamic and open marketplace. An approach that focuses solely on maximizing short-term profits without considering the competitive landscape is professionally unacceptable. Such a focus can lead to practices that, while profitable in the immediate term, may violate Alabama's competition law by creating barriers to entry, engaging in predatory pricing, or forming illegal cartels, ultimately harming consumers and the overall economy of Alabama. Another professionally unacceptable approach is to assume that any business practice not explicitly prohibited by a specific statute is permissible. Alabama's competition law, like most antitrust frameworks, is designed to address a wide range of anti-competitive conduct, including conduct that may not be explicitly listed, but has the effect of substantially lessening competition or tending to create a monopoly. This interpretation overlooks the broad prohibitory language and the underlying intent of the law. Furthermore, an approach that relies on the absence of competitor complaints as a sign of compliance is flawed. Competitors may be unaware of the full extent of an anti-competitive practice, may lack the resources to challenge it, or may fear retaliation. The absence of complaints does not equate to legal or ethical compliance with Alabama's competition law, which is designed to protect the market and consumers, not just to respond to formal grievances. The professional decision-making process for similar situations should involve a thorough understanding of the objectives of Alabama's competition law. This includes identifying potential impacts on market structure, consumer choice, and price levels. When evaluating a business strategy, professionals should ask, does this action likely reduce competition in Alabama? Does it harm consumers by leading to higher prices, reduced quality, or less innovation? Does it create unfair advantages that are not based on superior performance? Engaging legal counsel specializing in Alabama antitrust law is crucial for navigating complex situations and ensuring compliance. Question 12. Risk assessment procedures indicate that a proposed merger between two significant Alabama-based widget manufacturers warrants scrutiny under Alabama competition law. Which of the following approaches best ensures compliance with the law's prohibition against mergers that substantially lessen competition or tend to create a monopoly within Alabama? Option A. Focus primarily on the aggregate revenue of the merging companies to determine if their combined size exceeds a predetermined threshold, irrespective of their specific market positions within Alabama. Option B. Rely on the absence of any formal complaints from Alabama consumers or businesses regarding the proposed merger as sufficient evidence that competition will not be substantially lessened. Option C. Conduct a thorough analysis of the relevant product and geographic markets within Alabama, evaluating the combined entity's market share, potential for increased market power, barriers to entry for new competitors in Alabama, and the likelihood of anti-competitive conduct, while also considering any pro-competitive efficiencies. Option D. Prioritize the potential for cost reductions and operational synergies for the merging firms, assuming these efficiencies will automatically translate into benefits for Alabama consumers. The correct answer is C. Conduct a thorough analysis of the relevant product and geographic markets within Alabama, evaluating the combined entity's market share, potential for increased market power, barriers to entry for new competitors in Alabama, and the likelihood of anti-competitive conduct, while also considering any pro-competitive efficiencies. Explanation. Scenario analysis. This scenario is professionally challenging because assessing the competitive effects of a merger under Alabama law requires a nuanced understanding of market dynamics and the potential for anti-competitive outcomes. The challenge lies in distinguishing between pro-competitive efficiencies and genuine harm to competition, which can have significant implications for consumers and the Alabama economy. Careful judgment is required to avoid both blocking beneficial mergers and allowing harmful ones. Correct approach analysis. The best professional practice involves a comprehensive analysis that considers the relevant product and geographic markets within Alabama. This approach necessitates evaluating the combined entity's market share, the potential for increased market power, barriers to entry for new competitors in Alabama, and the likelihood of coordinated or unilateral anti-competitive conduct. Furthermore, it requires assessing any potential pro-competitive efficiencies that might offset anti-competitive concerns, all within the framework of Alabama's antitrust laws, particularly focusing on whether the merger is likely to substantially lessen competition or tend to create a monopoly in any relevant market in Alabama. This aligns with the statutory mandate to protect competition within the state. Incorrect approaches analysis. One incorrect approach would be to solely focus on the size of the merging entities without a detailed market analysis. This fails to account for the specific competitive landscape in Alabama and ignores the possibility that even large firms might operate in highly competitive markets or that a merger might have minimal impact on Alabama consumers. This approach risks either blocking pro-competitive mergers or failing to identify genuinely anti-competitive ones. Another incorrect approach would be to prioritize potential cost savings or operational efficiencies above all else, without adequately considering the impact on competition. While efficiencies can be a factor, they do not automatically justify a merger that would substantially lessen competition in Alabama. Alabama antitrust law requires a balancing of competitive effects, and an exclusive focus on efficiencies can lead to a disregard for consumer welfare and market fairness. A further incorrect approach would be to rely solely on the absence of explicit consumer complaints. The absence of complaints does not equate to the absence of anti-competitive harm. Consumers may not be aware of the subtle ways competition has been reduced, or they may lack the means to effectively voice their concerns. A proactive assessment of market structure and competitive dynamics is essential, rather than waiting for evidence of harm to manifest through complaints. Professional reasoning. Professionals should adopt a structured, evidence-based approach. This involves defining relevant markets, analyzing market shares and concentration, assessing barriers to entry, and evaluating the likelihood of anti-competitive effects. It also requires considering any claimed deficiencies and their potential to benefit consumers. This comprehensive evaluation, grounded in the principles of Alabama antitrust law, ensures that decisions are made in a manner that best protects competition and consumer welfare within the state. Question 13. Market research demonstrates that a dominant firm in the Alabama market for specialized medical devices has recently implemented a new pricing strategy that significantly undercuts its smaller rivals, leading to the exit of two competitors. While the firm claims this strategy is aimed at increasing overall market efficiency and accessibility of these devices to Alabama hospitals, some smaller competitors allege predatory pricing intended to eliminate them from the market. Considering the economic rationale for competition law in Alabama, which of the following approaches best guides the assessment of this situation? Option A. Prioritize the protection of the smaller medical device firms from aggressive pricing by the dominant firm, as maintaining a diverse set of suppliers is crucial for the long-term health of the Alabama healthcare market. Option B. Assume that any pricing strategy that leads to the exit of competitors is inherently anti-competitive and therefore a violation of Alabama's competition law, focusing on the reduction in the number of market participants. Option C. Conduct a thorough economic analysis to determine if the pricing strategy has resulted in, or is likely to result in, a substantial lessening of competition that harms consumer welfare in Alabama, focusing on whether prices are below an appropriate measure of cost and whether the firm has a dangerous probability of recouping its losses. Option D. Investigate the dominant firm's intent and determine if its primary objective was to drive smaller competitors out of business, regardless of the ultimate impact on prices or product availability for Alabama consumers. The correct answer is C. Conduct a thorough economic analysis to determine if the pricing strategy has resulted in, or is likely to result in, a substantial lessening of competition that harms consumer welfare in Alabama, focusing on whether prices are below an appropriate measure of cost and whether the firm has a dangerous probability of recouping its losses. Explanation. This scenario is professionally challenging because it requires a nuanced understanding of the economic rationale behind Alabama's competition law, specifically the concept of consumer welfare. The challenge lies in distinguishing between actions that genuinely harm competition by reducing consumer welfare and those that might appear anti-competitive on the surface, but actually lead to greater efficiency or innovation, ultimately benefiting consumers. A superficial analysis could lead to misinterpreting legitimate business strategies as violations. The best professional approach involves a rigorous economic analysis that prioritizes the impact on consumer welfare as the primary determinant of whether an action violates Alabama's competition law. This approach aligns with the core economic rationale underpinning such laws, which is to prevent monopolies and cartels that exploit consumers through higher prices, reduced output, or diminished quality and innovation. Specifically, it requires assessing whether the alleged anti-competitive conduct has led to, or is likely to lead to, a substantial lessening of competition that harms consumers. This involves considering factors such as market power, barriers to entry, and the potential for the conduct to result in higher prices or reduced choice for Alabama consumers. The Alabama Competition Act, like most modern competition regimes, is fundamentally concerned with protecting the competitive process to ensure that markets function efficiently and deliver benefits to consumers. An incorrect approach would be to focus solely on the intent of the firms involved. While intent can be a factor, competition law is primarily concerned with the effects of conduct, not just the motivations behind it. Judging a situation solely on whether firms intended to harm competitors or gain market share, without analyzing the actual or probable impact on consumer welfare, is a significant regulatory failure. It risks penalizing firms for aggressive but legitimate competition or failing to address conduct that, regardless of intent, harms consumers. Another incorrect approach is to assume that any action that increases a firm's market share or reduces the number of competitors is inherently anti-competitive. This overlooks the possibility that increased market share might be the result of superior efficiency, innovation, or product quality, which are desirable outcomes of a competitive market. Focusing on market structure alone, without examining the conduct and its impact on consumer welfare, is a failure to adhere to the economic rationale of competition law. Alabama's law aims to protect the competitive process, not necessarily the existence of a large number of competitors if that structure does not serve consumer interests. Finally, an incorrect approach would be to prioritize the protection of individual competitors over the broader interests of consumers. Competition law is not designed to shield inefficient firms from competition. If a firm is outcompeted due to its own inefficiencies, that is a natural outcome of a healthy market. Focusing on preventing firms from being disadvantaged by more efficient rivals, rather than on whether consumers are being harmed, represents a misapplication of the law's economic rationale. The professional decision-making process should involve a structured economic assessment. First, identify the relevant market. Second, analyze the market structure and the market power of the firms involved. Third, evaluate the specific conduct in question and its actual or probable effects on competition and, crucially, on consumer welfare within Alabama. This requires considering evidence of price effects, output restrictions, quality degradation, and stifled innovation. Only after this comprehensive analysis can a determination be made as to whether a violation of Alabama's competition law has occurred. Question 14. Risk assessment procedures indicate that a dominant fertilizer supplier in Alabama may be exercising significant market power. Which of the following analytical approaches would best satisfy the requirements of Alabama competition law when evaluating this supplier's market power? Option A. An evaluation focused exclusively on the supplier's historical profit margins, considering sustained high profits as the definitive indicator of market power. Option B. A comprehensive analysis that defines the relevant product in geographic markets and then examines the supplier's ability to unilaterally raise prices, the presence and strength of competitors, barriers to entry, and buyer power. Option C. An assessment based primarily on the supplier's current market share percentage, assuming that a high percentage directly equates to significant market power. Option D. A determination based solely on the number of competing fertilizer suppliers in Alabama, without considering their individual market impact or the ease of new market entry. The correct answer is B. A comprehensive analysis that defines the relevant product in geographic markets and then examines the supplier's ability to unilaterally raise prices, the presence and strength of competitors, barriers to entry, and buyer power. Explanation. Scenario analysis. This scenario presents a professional challenge because determining market power in Alabama's agricultural sector, specifically for a dominant fertilizer supplier, requires a nuanced understanding of economic principles and their application within the framework of Alabama's antitrust laws. The challenge lies in moving beyond superficial market share figures to a comprehensive assessment that considers the dynamic nature of competition, potential barriers to entry, and the actual ability of a firm to unilaterally influence prices or exclude rivals. Misjudging market power can lead to incorrect conclusions about potential anti-competitive conduct, impacting regulatory decisions and potentially harming consumers or other businesses in Alabama. Correct approach analysis. The best professional practice involves a holistic assessment of market power that begins with defining the relevant product in geographic markets. For a fertilizer supplier in Alabama, this means identifying the specific types of fertilizers sold and the geographic area where those fertilizers are realistically substitutable and accessible to consumers. Following market definition, the analysis must then incorporate a range of factors beyond simple market share. This includes examining the firm's ability to raise prices above competitive levels without losing significant business, the presence and strength of competitors, even if they have smaller market shares, the ease with which new competitors could enter the market, and the bargaining power of buyers. This comprehensive approach aligns with the spirit and intent of Alabama's antitrust laws, which aim to prevent monopolistic practices and promote fair competition by focusing on the substantive economic realities of market power. Incorrect approach is analysis, relying solely on a high market share percentage without considering the other factors, is a flawed approach. While market share can be an indicator, it is not determinative of market power. Alabama's antitrust framework recognizes that a firm with a large share might still face significant competitive constraints. This approach fails to account for potential substitutes, buyer power, or the threat of new entry, all of which can limit a firm's ability to exercise market power. Focusing exclusively on the firm's historical profitability as the sole measure of market power is also insufficient. High profits can result from efficiency, innovation, or favorable market conditions, rather than from the exercise of market power. Alabama's antitrust laws are concerned with the ability to control prices or exclude competition, not simply with the outcome of profitability. This approach risks misinterpreting success as anti-competitive behavior, considering only the number of competitors, without evaluating their actual competitive significance or the barriers to entry for new firms. Presents another, inadequate method. A market with many small competitors might still be dominated by one firm if the others lack the capacity or incentive to challenge its pricing or output decisions, or if significant barriers prevent new, more competitive firms from entering. This approach overlooks the qualitative aspects of competition and the structural impediments that can solidify market power. Professional reasoning. Professionals assessing market power under Alabama competition law should adopt a structured, evidence-based approach. This begins with clearly defining the relevant product in geographic markets. Subsequently, A multifaceted analysis should be conducted, integrating quantitative data, like market share, with qualitative factors such as the ease of entry and exit, the nature of buyer power, and the substitutability of products. This comprehensive evaluation ensures that conclusions about market power are grounded in economic reality and consistent with the objectives of Alabama's antitrust statutes, which are designed to protect competition and prevent undue market control. Question 15. The performance metrics show a significant decline in new entrants into the Alabama poultry processing market over the past 5 years, coupled with a notable increase in the market share of the largest incumbent processor. Considering the Alabama competition law, which of the following analytical approaches best addresses the potential for anti-competitive conduct? Option A. Conduct a detailed analysis of specific barriers to entry and exit within the Alabama poultry processing sector, such as capital requirements, supply chain control, and regulatory compliance, to determine if they are artificially inflated or maintained by the incumbent. Option B. Dismiss the observed market trends by asserting that the Alabama poultry processing market is inherently too small to attract significant new competition, thus negating the need for further antitrust scrutiny. Option C. Focus primarily on the incumbent processor's current profitability as the main indicator of potential anti-competitive behavior, assuming high profits directly correlate with illegal market foreclosure. Option D. Conclude that the market concentration is a natural outcome of economies of scale and the incumbent's superior efficiency, without further investigation into the specific dynamics of market entry. Correct answer is A. Conduct a detailed analysis of specific barriers to entry and exit within the Alabama poultry processing sector, such as capital requirements, supply chain control, and regulatory compliance, to determine if they are artificially inflated or maintained by the incumbent. Explanation. The performance metrics show a significant decline in new entrants into the Alabama poultry processing market over the past 5 years, coupled with a notable increase in the market share of the largest incumbent processor. This scenario is professionally challenging because it requires an assessment of whether the observed market dynamics are the result of natural competitive forces or anti-competitive conduct that may violate Alabama antitrust laws, specifically the Alabama competition law. Careful judgment is required to distinguish between legitimate business strategies and actions that unlawfully foreclose competition. The best professional approach involves a thorough investigation into the specific barriers to entry and exit that may be impacting the Alabama poultry processing market. This includes examining factors such as high capital investment requirements for new processing facilities, exclusive supply contracts between the incumbent and local farmers, regulatory hurdles unique to the state, and the incumbent's pricing strategies that might deter new entrants. Understanding these specific barriers is crucial for determining if they are artificially maintained or exacerbated by anti-competitive practices, thereby potentially violating Section 6-5-60 of the Code of Alabama. This approach aligns with the principles of robust antitrust enforcement, which seeks to identify and remedy conduct that harms competition and consumers. An incorrect approach would be to assume that the observed market concentration is solely a natural consequence of economies of scale and efficiency. While scale can be a legitimate competitive advantage, it becomes problematic under antitrust law if it is leveraged to create or maintain artificial barriers to entry. Simply accepting the market structure without scrutinizing the underlying causes of limited new entry risks, overlooking potential violations of the Alabama competition law. Another professionally unacceptable approach is to focus solely on the profitability of the incumbent processor. High profits in isolation do not necessarily indicate anti-competitive behavior. However, if those profits are derived from practices that unlawfully restrict competition, such as predatory pricing or exclusionary dealing, then they become evidence of a violation. Ignoring the mechanisms by which those profits are generated and their impact on market entry is a significant oversight. Furthermore, an approach that dismisses the issue by stating that the market is too small to attract new competitors is also flawed. The Alabama competition law is designed to protect competition within the state, regardless of the absolute size of the market. The focus should be on whether existing or potential competition is being unlawfully suppressed, not on whether the market is large enough to naturally attract a multitude of players. The professional decision-making process for similar situations should involve a systematic evaluation of market structure, conduct, and performance, with a particular emphasis on identifying and analyzing barriers to entry and exit. This requires gathering evidence on the specific factors that influence new firms' ability to enter and existing firms' ability to exit the market, and then assessing whether these factors are a result of legitimate business practices or anti-competitive actions prohibited by Alabama law. Question 16. The audit findings indicate that a dominant firm in the Alabama market for specialized industrial lubricants has recently acquired exclusive supply agreements with all major raw material providers in the state. These agreements prevent competitors from accessing essential inputs, and the dominant firm has simultaneously increased its prices for finished lubricants. What is the most appropriate initial step for the company's legal and compliance team to take in response to these audit findings under Alabama antitrust law? Option A. Immediately issue a public statement denying any anti-competitive intent and emphasizing the company's commitment to innovation and consumer value. Option B. Advise the dominant firm to cease all exclusive supply agreements immediately based on the presumption that such agreements are inherently anti-competitive. Option C. Focus solely on the dominant firm's profit margins to determine if they have exceeded a reasonable rate of return, as this is a primary indicator of antitrust violation. Option D. Conduct a thorough market analysis to define the relevant product in geographic markets in Alabama, assess the dominant firm's market power, and evaluate the competitive effects of the exclusive supply agreements and subsequent price increases. Correct answer is D. Conduct a thorough market analysis to define the relevant product in geographic markets in Alabama, assess the dominant firm's market power, and evaluate the competitive effects of the exclusive supply agreements and subsequent price increases. Explanation. The audit findings indicate a potential violation of Alabama antitrust laws, specifically concerning monopolization or attempts to monopolize. This scenario is professionally challenging because it requires a nuanced understanding of market power, competitive effects, and the intent behind business practices, all within the framework of the Alabama Competition Act. Misinterpreting these factors could lead to significant legal penalties, reputational damage, and harm to consumers. The best approach involves a thorough investigation into the alleged conduct, focusing on whether the company's actions have substantially lessened competition or created a dangerous probability of monopolization within the relevant market in Alabama. This requires gathering evidence on market definition, market share, barriers to entry, the nature of the alleged exclusionary conduct, and its actual or probable anti-competitive effects. The Alabama Competition Act prohibits monopolization and attempts to monopolize. Therefore, a comprehensive assessment of market power and the impact of the conduct on competition is paramount. This approach aligns with the statutory intent to protect the competitive process and consumer welfare by preventing firms from abusing dominant positions, an approach that immediately assumes illegality based solely on market share, without considering the competitive effects or the legality of the underlying business practices, is flawed. Market share alone is not determinative of a violation. It is the use of that market power to harm competition that is prohibited. This approach risks overreach and penalizing legitimate business success. Another incorrect approach would be to dismiss the concerns by focusing only on the company's intent to increase profits, without analyzing whether the methods used to achieve those profits are anti-competitive. While profit motive is a legitimate business goal, the Alabama Competition Act scrutinizes the means by which profits are pursued if they involve anti-competitive conduct. Ignoring the competitive impact of the actions, even if the intent was not explicitly malicious, is a regulatory failure. Finally, an approach that relies on anecdotal evidence or competitor complaints without objective market analysis is insufficient. While such information may trigger an investigation, a definitive conclusion requires rigorous economic and legal analysis of the relevant market and the conduct's impact, as mandated by antitrust principles. Professionals should employ a decision-making framework that begins with identifying potential antitrust concerns, followed by a detailed factual investigation. This investigation should involve defining the relevant market, assessing market power, analyzing the specific conduct in question, and evaluating its actual or probable anti-competitive effects. Legal counsel specializing in antitrust law should be consulted to interpret the Alabama Competition Act and guide the analysis, ensuring compliance with all statutory requirements and case law. Question 17. Cost-benefit analysis shows that a proposed joint purchasing agreement among several independent Alabama hardware retailers could lead to significant cost savings for the retailers through bulk discounts. However, this agreement would also involve setting minimum resale prices for certain common hardware items sold by these retailers within Alabama. Considering the Alabama competition law, what is the most appropriate course of action for the retailers to ensure compliance? Option A. Abandon the joint purchasing agreement entirely, as any agreement between competitors that involves price coordination, even for resale, is per se illegal under Alabama antitrust laws. Option B. Proceed with the joint purchasing agreement, but carefully document the cost savings and consumer benefits, while seeking legal counsel to structure the resale price provisions to minimize anti-competitive effects and ensure they do not lead to a substantial lessening of competition in the Alabama market. Option C. Proceed with the joint purchasing agreement and the minimum resale price provisions, assuming that the cost savings are so substantial that they outweigh any potential negative impact on competition in Alabama. Option D. Implement the joint purchasing agreement and the minimum resale price provisions immediately, as the cost savings for retailers will ultimately benefit consumers through potentially lower operating costs passed on. The correct answer is B. Proceed with the joint purchasing agreement, but carefully document the cost savings and consumer benefits, while seeking legal counsel to structure the resale price provisions to minimize anti-competitive effects and ensure they do not lead to a substantial lessening of competition in the Alabama market. Explanation: this scenario is professionally challenging because it requires a nuanced understanding of Alabama antitrust law, specifically concerning agreements between competitors. The core difficulty lies in distinguishing between legitimate business collaborations that can enhance efficiency and potentially benefit consumers, and illegal agreements that restrict competition. A careful judgment is required to avoid both over-enforcement, which could stifle innovation and beneficial business practices, and under-enforcement, which could allow harmful cartels to persist. The correct approach involves a thorough assessment of the agreement's potential effects on competition within the relevant Alabama market. This means evaluating whether the agreement is likely to lead to higher prices, reduced output, or diminished quality for consumers. Specifically, it requires analyzing the nature of the agreement, the market power of the participating firms, and the existence of any pro-competitive justifications. If the agreement is found to substantially lessen competition or tend to create a monopoly in any line of commerce in Alabama, it would likely violate the Alabama competition law. This approach aligns with the principles of antitrust law, which aim to protect the competitive process and consumer welfare. An incorrect approach would be to assume that any agreement between competitors is inherently illegal. This oversimplifies the law and ignores the possibility of legitimate joint ventures or collaborations that can lead to efficiencies and consumer benefits. Such an assumption could lead to the prosecution of pro-competitive conduct, which is contrary to the goals of antitrust enforcement. Another incorrect approach is to focus solely on the intent of the parties involved, without adequately considering the actual or probable effects of the agreement on competition. While intent can be a factor, antitrust law primarily concerns itself with the competitive impact of conduct. An agreement with no anti-competitive effect, even if motivated by a desire to reduce competition, may not be illegal. Conversely, an agreement that has a significant anti-competitive effect may be illegal even if the parties claim they did not intend to harm competition. A further incorrect approach would be to permit the agreement solely because it offers some benefit to the participating firms, without a rigorous analysis of its impact on the broader market and consumers in Alabama. Antitrust law is designed to protect competition, not necessarily individual firms. Benefits to the firms themselves are only relevant if they translate into benefits for consumers through lower prices, higher quality, or greater innovation. The professional decision-making process for similar situations should involve a structured analysis. First, identify the relevant market in Alabama. Second, assess the nature of the agreement and the market power of the parties. Third, evaluate the potential pro-competitive justifications for the agreement. Fourth, determine the likely effects of the agreement on competition and consumer welfare within Alabama. If the agreement is likely to cause substantial harm to competition without sufficient pro-competitive benefits, it should be challenged. Question 18. Quality control measures reveal that a manufacturer of premium Alabama-made artisanal cheeses has entered into exclusive distribution agreements with several retailers across the state. These agreements stipulate that the retailers will only sell this manufacturer's cheeses and will not carry competing brands. The manufacturer asserts that this exclusivity is necessary to ensure proper handling, storage, and presentation of their delicate products, thereby protecting their brand reputation and consumer satisfaction. A competitor has raised concerns that these agreements may be limiting consumer choice and foreclosing other cheese producers from accessing significant retail channels in Alabama. Which of the following represents the most appropriate course of action for the manufacturer and its distributors under Alabama competition law? Option A. Assume that because the cheeses are premium and artisanal, the exclusive agreements are automatically exempt from scrutiny under Alabama competition law, regardless of their market effect. Option B. Rely solely on the manufacturer's stated intent to protect brand image and product quality as sufficient justification, without further investigation into the market impact of the exclusivity. Option C. Conduct a comprehensive analysis of the exclusive dealing arrangement's impact on competition within the relevant Alabama cheese market, considering potential pro-competitive justifications against any demonstrable anti-competitive effects, and document this analysis thoroughly. Option D. Immediately cease all exclusive distribution agreements across Alabama, as any restriction on a retailer's ability to carry competing products is per se illegal under Alabama competition law. The correct answer is C. Conduct a comprehensive analysis of the exclusive dealing arrangement's impact on competition within the relevant Alabama cheese market, considering potential pro-competitive justifications against any demonstrable anti-competitive effects, and document this analysis thoroughly. Explanation. Scenario analysis. This scenario presents a professional challenge because it requires balancing the legitimate business interests of a manufacturer in maintaining product quality and brand reputation with the potential for anti-competitive effects arising from its distribution agreements. The Alabama competition law, particularly its provisions concerning vertical restraints, demands careful analysis to distinguish between pro-competitive justifications and conduct that unduly restricts competition. The challenge lies in applying the relevant legal standards to the specific facts of the agreement and the market context. Correct approach analysis. The best professional approach involves a thorough assessment of the agreement's potential impact on competition within the relevant Alabama market. This requires understanding the specific terms of the agreement, the nature of the product, the market share of the parties involved, and the existence of any pro-competitive justifications. Specifically, it necessitates evaluating whether the exclusive dealing arrangement significantly forecloses competition by preventing other distributors from accessing the market or other manufacturers from accessing consumers. This aligns with the principles of Alabama antitrust law, which often employs a rule of reason analysis for vertical restraints, weighing the pro-competitive benefits against the anti-competitive harms. The focus is on the actual or probable effect on competition, not merely the intent of the parties. Incorrect approaches analysis. One incorrect approach would be to assume that any exclusive dealing arrangement is inherently illegal under Alabama competition law simply because it limits the choices of distributors. This overlooks the fact that many vertical agreements can have pro-competitive justifications, such as promoting interbrand competition, enhancing product quality, or facilitating market entry. Another incorrect approach would be to solely focus on the manufacturer's stated intent to maintain brand image without considering the broader market impact. While brand image is a legitimate business concern, it does not automatically shield an agreement from antitrust scrutiny if its effect is to substantially lessen competition. Finally, an approach that relies on a superficial comparison to other industries without analyzing the specific market dynamics in Alabama would be flawed. Each market and each agreement must be assessed on its own merits under the applicable Alabama law. Professional reasoning. Professionals should approach such situations by first identifying the relevant market and the parties' positions within it. They should then meticulously analyze the specific terms of the vertical agreement and its potential effects on competition, considering both pro-competitive justifications and anti-competitive harms. This analysis should be grounded in the principles of Alabama competition law, particularly the rule of reason where applicable. Consulting with legal counsel specializing in Alabama antitrust law is crucial to ensure compliance and to navigate the complexities of vertical restraint analysis. Question 19. Stakeholder feedback indicates a growing concern regarding the competitive landscape in Alabama's automotive repair industry. A large, established automotive parts distributor in Birmingham, Alabama, proposes to acquire a significant chain of independent auto repair shops operating throughout the state of Alabama. This acquisition would give the distributor a substantial presence in both the supply of parts and the provision of repair services. Considering the potential impact on competition within Alabama, how should this proposed merger be primarily analyzed under Alabama's antitrust framework? Option A. Assume the merger is anti-competitive due to the increased market power of a single entity in the automotive sector within Alabama and seek to block it based on this presumption. Option B. Classify the merger based on the geographic reach of the merging companies within Alabama, focusing on whether their combined operations will cover a larger portion of the state's territory. Option C. Analyze the merger by determining if the merging entities operate at the same level of the supply chain and in the same product market within Alabama, and if so, assess whether this integration is likely to substantially lessen competition or tend to create a monopoly in the relevant Alabama markets. Option D. Evaluate the merger by considering the potential for the acquiring distributor to diversify its business interests into the automotive repair sector, regardless of its impact on existing competition in either sector. The correct answer is C. Analyze the merger by determining if the merging entities operate at the same level of the supply chain and in the same product market within Alabama, and if so, assess whether this integration is likely to substantially lessen competition or tend to create a monopoly in the relevant Alabama markets. Explanation. Scenario analysis. This scenario is professionally challenging because it requires a nuanced understanding of Alabama's antitrust laws, specifically the Clayton Act as interpreted by the Alabama Attorney General's office, to determine the legality of a proposed merger. The challenge lies in accurately classifying the merger and assessing its potential impact on competition within Alabama's specific market. Misclassification or an incomplete analysis could lead to significant legal repercussions, including injunctions, divestitures, and substantial fines, harming both the companies involved and the consumers in Alabama. Careful judgment is required to distinguish between different merger types and their respective competitive concerns. Correct approach analysis. The best professional approach involves a thorough analysis of the proposed merger structure and its likely effect on competition within the relevant Alabama market. This means identifying whether the merging entities operate at the same level of the supply chain and in the same product market, which would classify it as a horizontal merger. Subsequently, the analysis must focus on whether this horizontal integration is likely to substantially lessen competition or tend to create a monopoly in Alabama, as prohibited by Section 7 of the Clayton Act, as applied in Alabama. This approach directly addresses the core concerns of antitrust enforcement by examining market concentration, potential for coordinated or independent anti-competitive conduct, and barriers to entry within the specific geographic and product markets in Alabama. Incorrect approach is analysis. One incorrect approach would be to solely focus on the geographic overlap of the merging companies without considering their position in the supply chain. This would fail to differentiate between horizontal, vertical, and conglomerate mergers, potentially mischaracterizing the competitive risks. For instance, a merger with significant geographic overlap, but no overlap in the supply chain, might not raise the same antitrust concerns as a horizontal merger. Another incorrect approach would be to assume that any merger between companies in the same industry is automatically problematic. This overlooks the possibility of efficiencies or the fact that some mergers, even if horizontal, may not substantially lessen competition. Alabama antitrust law, like federal law, requires an assessment of the actual or probable effect on competition, not a blanket prohibition. A further incorrect approach would be to classify the merger based on its potential for diversification, without considering its impact on existing competition. While conglomerate mergers are generally viewed with less antitrust scrutiny than horizontal ones, a poorly analyzed conglomerate merger could still raise concerns if it leads to entrenchment or other anti-competitive effects in related markets. The primary focus must remain on the direct impact on competition in the relevant markets. Professional reasoning. Professionals should adopt a structured decision-making framework when evaluating mergers under Alabama antitrust law. This framework should begin with clearly defining the relevant product and geographic markets within Alabama. Next, the structure of the merger must be meticulously analyzed to determine if it is horizontal, vertical, or conglomerate. For each type, specific competitive concerns must be assessed according to Alabama's interpretation of federal antitrust principles. This involves evaluating market shares, concentration ratios, barriers to entry, potential for anti-competitive coordination, and any claimed pro-competitive efficiencies. The ultimate determination must be whether the merger is likely to substantially lessen competition or tend to create a monopoly within Alabama. Question 20. Regulatory review indicates that Southern Steelworks, Inc. operates in the Alabama steel fabrication market. The market is characterized by three major firms: Southern Steelworks, Inc., Dixie Metalworks LLC, and Gulf Coast Fabricators, Inc., which together hold 95% of the market share. Southern Steelworks, Inc. has a market share of 40%, Dixie Metalworks LLC has 35%, and Gulf Coast Fabricators, Inc. has 20%. The remaining 5% is held by numerous smaller regional fabricators. Southern Steelworks, Inc. is proposing a significant price increase for its standard steel beams. Based on Alabama competition law, what is the most appropriate initial step to assess the potential anti-competitive implications of this proposed price increase? Option A. Assume that the presence of numerous smaller regional fabricators, even with a combined 5% market share, prevents any form of collusion or unilateral exercise of market power by the larger firms. Option B. Calculate the Herfindahl-Hirschman Index, HHI, for the Alabama steel fabrication market and evaluate it in conjunction with other qualitative indicators of oligopoly to determine the level of market concentration. Option C. Immediately conclude that Southern Steelworks, Inc.'s proposed price increase is anti-competitive due to its dominant market share and the limited number of major competitors. Option D. Focus solely on Southern Steelworks, Inc.'s historical profit margins to determine if the proposed price increase is excessive and indicative of market power abuse. The correct answer is B. Calculate the Herfindahl-Hirschman Index, HHI, for the Alabama steel fabrication market and evaluate it in conjunction with other qualitative indicators of oligopoly to determine the level of market concentration. Explanation. This scenario presents a professional challenge because it requires the application of economic principles to assess market competition within the specific legal framework of Alabama. The challenge lies in accurately interpreting market data and applying the relevant Alabama competition law provisions to determine if a firm's pricing strategy constitutes anti-competitive behavior, particularly in a market structure that appears to lean towards oligopoly. Misinterpreting the market structure or failing to correctly apply the legal tests could lead to incorrect conclusions about the legality of pricing practices, potentially resulting in regulatory scrutiny or missed opportunities for intervention. The best approach involves a rigorous calculation of market concentration using the Herfindahl-Hirschman Index, HHI, and comparing it against established thresholds, while also considering qualitative factors indicative of oligopolistic behavior under Alabama law. This approach is correct because it directly addresses the quantitative measures of market concentration that are central to identifying potential anti-competitive effects. Alabama's competition law, like many antitrust frameworks, relies on market share and concentration metrics to flag markets for further investigation. Calculating the HHI provides an objective measure of market concentration. A high HHI score, particularly when combined with other indicators of oligopoly, e.g., few dominant firms, high barriers to entry, interdependent pricing, strongly suggests that the market structure may facilitate collusion or unilateral exercise of market power, which are concerns under Alabama's competition law. This data-driven, legally grounded analysis ensures that any assessment of market power is based on concrete evidence and established legal standards. An incorrect approach would be to solely rely on the number of competitors without performing a quantitative concentration analysis. While the presence of a few firms is characteristic of an oligopoly, simply counting them does not provide the necessary depth to assess the degree of market power or the likelihood of collusion. Alabama's competition law requires a more nuanced understanding of market concentration than a simple head count. Another incorrect approach would be to focus exclusively on the firm's profit margins without considering the market structure. High profits can arise from various factors, including efficiency, innovation, or simply a well-functioning competitive market, without analyzing the market structure and concentration. Attributing high profits solely to anti-competitive behavior is speculative and not supported by the legal framework. Alabama's competition law is concerned with the structure and conduct that leads to anti-competitive outcomes, not just the outcomes themselves in isolation. A further incorrect approach would be to assume that any price increase by a dominant firm in an oligopoly is automatically illegal. Alabama's competition law does not prohibit all price increases. Instead, it scrutinizes pricing behavior in the context of market power and its potential to harm competition. A thorough analysis requires demonstrating how the pricing strategy within the specific market structure is likely to result in reduced output, higher prices for consumers, or diminished innovation, rather than making a blanket assumption of illegality. Professionals should adopt a decision-making framework that begins with defining the relevant market and calculating market shares and concentration metrics, like the HHI, and finally assessing the market structure in light of Alabama's competition law. This involves considering barriers to entry, the nature of the product, and the degree of interdependence among firms. If the analysis indicates a highly concentrated market with potential for collusion or unilateral exercise of market power, further investigation into specific conduct, such as pricing strategies, is warranted.